In the previous video, we had a look at the three certainties and we started talking about the certainty of intention. And specifically, we were looking at a few different cases, such as Lamb and Eves and Adams and Comiskey, and some particular sort of phrases to determine whether or not there was a certainty of intention. And this video just continues with our discussion about certainty of intention. So, Section 22 of the Administration of Justice Act. Except where a contrary intention is shown, it shall be presumed that if a testator devises or bequeaths a property to his spouse in terms which in themselves would give an absolute interest to the spouse, but by the same instrument purports to give his issue, that is, his lineal descendants, an interest in the same property, the gift to the spouse is absolute, notwithstanding the purported gift to the issue. So, as far as I can tell, this has never actually been applied. So, this section means that if a testator under a will leaves property to a spouse, and then when the spouse dies, the property is to go to the spouse's children, this will not create a trust, okay? So, note, this section only applies to the testator's spouse's children, okay? It doesn't apply to any other relationship. So it has to be a will trust, it has to be property left to the wife or husband, and the remainder or purported trust have to be in favour of the children. So a remainder to grandchildren, nephews, nieces, etc. would not fall under this section, okay? So where there is a provision for the children in remainder, the part making the bequest to the beneficiary should be considered in isolation. If this part makes an absolute gift, then any subsequent qualification should not be considered as creating a trust. So, because there is originally a transfer of the property as an absolute gift to the spouse, any further attempts to dispose of the remainder in the property will not be valid. In other words, no trust will be created. Now, it should be noted that this only applies to bequests to spouses with remainder to the children. A similarly worded bequest to children with remainder to grandchildren would not fall within this section. And you can also see the Civil Partnership Act 2004, Schedule 4, Paragraph 5 for the identical provision for civil partners. So, as I've already mentioned, this section only applies to circumstances where the bequest has been made to the testator's spouse with remainder interest for their children, and there is a similar provision for civil partners. For example, I leave my house to my wife, and after her death to my children in equal shares, would not create a trust, notwithstanding the attempt to bequeath the house in remainder to the children. So this phrase would not create a trust because the first part is an absolute gift and the second part is an attempt to dispose of the remainder of the property. It does not create a trust if the original gift is to the wife and the remainder gift is to the children. So that would create an absolute bequest to the wife. She could therefore sell the house and abandon her children. Okay. So let's look at this case here of Harrison. So in this case, they tried to apply Section 22 of the Administration of Justice Act, but it turned out it wasn't actually applicable to this case. So the testator made a homemade will and said, "The bungalow I leave in trust for my wife. On her death, the bungalow is to be sold and cash raised is to be equally divided between my children." So this created a trust and not an absolute gift for his wife. He used the words in trust. Now, after his signature, he said, "No doubt, if mum runs into money problems, you can sort something out, like selling bungalow." Now, on her death, the widow left her property in unequal shares to 3 of her children, and this was in contrast to what she had been directed to do by the will. And the defendant relied upon Section 22 of the Administration of Justice Act 1982. So the defendant said the first part, the bequest to the wife, was a gift. Therefore, any conditions about leaving it equally to the children were not binding on her. However, if you look at the wording, this is really quite a hopeless claim, as the testator clearly states in the will that the property was to be left in trust for his wife. The court held that the wording of the bequest created an express trust, not a gift, with the provision for the remainder. So Section 22 did not apply. So the court found a trust whereby the wife would have the property during her lifetime, then it would be given to her children in equal shares when she died. Now, it should be noted that Section 22 is consistent with the decisions in both Comiskey and Adams, and we looked at both of those cases in part 1. So if you haven't checked out part 1 of these videos, then go check that out now. But in Adams, the gift in remainder was to the children, in which case the bequest fell within the terms of Section 22, and in Comiskey, the gift in remainder was to the nieces, in which case Section 22 does not apply. So in Adams, there was an absolute gift to the wife, with remainder being to the children, and this is consistent with Section 22, as it was held the wife took an absolute gift and there was no obligation for her to dispose the property to the children, and in Comiskey there was a remainder gift to the nieces and a trust was formed. So yeah, Section 22 is consistent with Comiskey too. So let's look at this other case of Burrough and Philcox from 1840. Now in this case, the testator left property in trust for his own children for their lifetime and then to their children. However, both his children died without issue. Now, this is a fairly common trust, and as we saw, in my previous videos, the rule against perpetuities means you cannot really do further than that. Well, you can if your children are alive when you die because they will be a life in being, but then property must vest. And previously, this was a life in being plus 21 years. Now it is 125 years. So if you haven't seen my videos on perpetuities, go check that out and I explain all of that too there. So the will provided in this event that the longest liver of my 2 children shall have power by a will properly attested in writing to dispose of all my real and personal estates amongst my nephews and nieces or their children, either all to one of them or to as many of them as my surviving child shall think proper. So there was a power given to the testator's children, the beneficiaries, to decide who should be the remainder beneficiary of this trust. Clearly, if the testator's children had children themselves, the property would pass to them. However, in the event they didn't have children, as occurred in this case, the beneficiaries had a power to dispose the property to the testator's nephews and nieces or their children. Okay. In the event the surviving child did not exercise the power to dispose of the property. So not only did the surviving child not have any children of his own, but didn't exercise the power he had under the trust which he was a beneficiary of. So the question was it the intention of the settler that the property was to be held on trust for the nephews and nieces, or grandnephews and nieces, or was it a mere power that the children could give to the nephews and nieces or their grandnephews and nieces? So that was the question here. Now the court held that the following: these and other cases shew that when there appears a general intention in favour of a class and a particular intention in favour of individuals of a class to be selected by another person, and the particular intention fails, from that selection not being made, the court will carry into effect the general intention in favour of the class. Okay, so the testator's intention to benefit his nephew and nieces or their children was not merely a power of appointment, but an intention to favour them, that is, to make a trust in their favour. So the court gave effect to that trust on the basis that equality is equity by dividing the property equally between the nephews and nieces and their children. So although the trust failed in that the children didn't dispose of the property using their power, the court was still able to ensure there was a trust in favour of the nephews and nieces and their children. When such an intention appears, the court arises as stated by Lord Eldon in Brown and Higgs of the power being so given as to make it the duty of the donee to execute it, and in such case the court will not permit the objects of the power to suffer by the negligence or conduct of the donee, but fastens upon the property a trust for their benefit. So that was said by Lord Cottenham. Now, so on a trust, on a true construction of the intention of the settler, if that true construction of the intention of the settler was to provide for his nephews and nieces, and the default of the children in exercising their power of appointment meant the court could divide the property equally between the nephews and nieces and their children. So that is the end of this video and the end of part 2 of certainty of intention. Now, in the next video, we're going to probably have one final video of certainty of intention, and it's going to be quite case heavy, and I'm going to be looking at inferred intention, looking at cases such as Twin, Sector and Yardley, and Poole and Constance, and I'm also going to have a little look at Cayford and something like Jones and Locke, and a bit about shams and fraud. So it's quite a heavy final video, I think, maybe on certainty of intention, because there's quite a few different cases that we need to explore and look at. But hopefully that should therefore wrap up our cases and our sort of our understanding of certainty of intention quite nicely. So yeah, if you have any questions about this video, then please leave a comment below and I'll get straight back to you. But other than that, make sure you subscribe to my channel and I shall see you next time. Thank you very much for watching.